Tell us something about yourself.
Ma'am, my name is Satyabhama Khaushiki. I completed my BA LLB 5-year integrated law from National Law University Ranchi in the year 2021. Currently, I am pursuing LLM from Allahabad University.
Oh, you're in which year of your first year in LLM?
No, ma'am. This is my 4th semester is about to complete.
It's the semester for the dissertation.
Yes, ma'am.
So what's the topic for the dissertation?
Ma'am, the Muslim Women Rights on Marriage Act 2019, which is also known as the Triple Talaq Act 2019.
So what new thing you are going to do in your research?
Ma'am, there are two specific areas which I have been able to identify till now. The first is I have tried to identify the drawback in the definition of triple talaq. The act of triple talaq per se is not harmful for the woman, but what happens after the pronouncement, that is harmful. She is either thrown out of the matrimonial household, or there is a demand for dowry, or there is some sort of cruelty. So according to me, the section should have been any act of pronouncement of triple talaq which injures the life, limb and health of the woman, that amounts to triple talaq. And then second, I have tried to identify some procedural problems. For example, the magistrate has only been bestowed the power to grant maintenance. According to me, there should have been provisions for residence order also, custody orders, which we find in Domestic Violence Act. That would have served the purpose of Triple Talaq Act.
What is section 167 of CRPC?
Ma'am, it talks about the default bail in case of non-completion of investigation within 24 hours.
What is section 309?
Ma'am, section 309, ma'am, it talks about the judicial custody which is granted during the pendency of the trial.
What is the difference between the inquiry which is conducted by the magistrate in section 159 CRPC and in section 202?
Ma'am, in section 159 CRPC, that is preliminary investigation, the order which the magistrate orders for, it is just to ascertain whether there is a possibility of conducting the investigation in this particular case or not. While in case of section 202, the cognizance is taken upon the complaint and the magistrate is trying to ascertain whether judicial notice can be taken in this case or not.
Recently, there was a case in 2023, Ajik Rahane versus Ajik Rahane. Have you heard?
No, sir, I'm sorry.
That was dealing with the DNA profiling. Okay.
What do you understand by euthanasia?
Ma'am, euthanasia is basically the self-killing of a person. So ma'am, as far as I'm updated on this, there are two specific case laws. One is Aruna Schonborg versus Union of India. Another is Common Cause Registered Society versus Union of India, which is a very recent case law, 2018. So ma'am, till now the status is active euthanasia is not allowed, but passive euthanasia is allowed, where the medical practitioner can omit to offer certain services to the patient. Sir, Common Cause Registered Society versus Union of India.
Okay. What is your take on the entire concept, on our entire debate of euthanasia? What is your take on this?
Ma'am, I believe I have to identify the practical lacuna has to be identified. If the patient himself or herself is unable to sustain the life, right to life also implies that I should be able to live as a human. And if the patient himself is claiming that he is not able to stretch his life as a human being anymore, so the legislature or the state does not have any agency to interfere in his personal decision.
So, and what about the probable misuse of this law? Don't you think that misuse of this law is a very big impediment, especially in females?
Ma'am, definitely it is, but the first, ma'am, factor would be that legislature cannot make law by keeping in mind the exceptional cases or lacuna that is going to follow. And second is, the legislature must take care of the drawbacks which is about to happen, and certain provisions can be made to encounter such problems. That would be a better solution.
What do you understand by the word justice? What does justice mean to you?
Ma'am, for me, as far if I am able to grant the adequate relief to a party which is best suited to the circumstances of the case and which is able to restore his position as much as possible in that case, so that is justice for me.
Tell me about 3 of your qualities which are going to be, your strength if you qualify this interview and you join judiciary.
Ma'am, first is I am a critical listener. I have all these years during my school and college and law school time, I have critically worked on my listening skills. I try to understand what the person is trying to say, and I try to derive a meaningful conclusion out of it. And I believe as a judge, I should be able to ascertain the arguments of the advocates and thereby come to a conclusion. That is the first. And ma'am, second, I am a very prompt person. I am a very punctual person, and I try to complete my task which is assigned to me as much and as expeditiously as possible. That is the second criteria, ma'am. And ma'am, third would be, as I have kept my ethics and integrity very intact. I have tried to work upon it as much as possible, and I will try to retain it in the longer run of the profession as well.
What is the meaning of socialist?
So socialist is a term which is used in the preamble. It basically means that the state must follow equitable principles in terms of distribution of wealth.
Where in any provision in the constitution which has defined the term socialist approach?
No, sir, there is no specific provision, but it's just that Article 39 provides the responsibility of the state that distribution of wealth and resources must be taken care of. There is no specific usage. There was one case law where the Supreme Court had laid down the meaning of socialist. That was, as far as I'm able to recall, Excelware versus Union of India.
Material distribution of the property among the citizens of India.
Yes.
Is it defined under Article 39 subclause B?
Sir, I'm sorry, I'm not able to recall the exact phrase.
Okay. What is the constitutional law?
So constitutional law, it is the grand norm of the country, and it is formally recognized under the Constitution of India 1950.
तो कैसे difference करेंगे constitution and constitutional law को?
So constitutional law is a wider ambit. Constitution per se is the statute. So constitutional law would cover a lot of aspects, like as I said, the features of the basic structure doctrine must be incorporated, and various principles of justice, equity, and fair conscience. So just constitutional law is a bigger ambit, and constitution is the statute. It is a species.